SJC-11978, Commonwealth v. Glennis A. AndonSoto.
I don't think any of the cases we have are easy to tell you the truth.
Morning, Mr. DeMayo.
Good morning, Your Honors. May it please the Court, Christopher DeMayo for Glennis AndonSoto. I'm going to try to address three issues today, time permitting. The first is the admissibility of my client's inability or failure to blow a readable breath sample into the breathalyzer. The second is the hearsay issues related to the translator. And third, confrontation clause issues related to the translator. So beginning with the breathalyzer issue.
Are we the only state in the country that currently does not allow the admission of a refusal evidence with respect to a breathalyzer?
I don't know that we're the only state.
I think we are. But go ahead.
But we do, we do have this, we have both the law that doesn't allow you to admit that testimony, and then there's a MCR code provision, which I put in the brief, which states that failure to blow adequate breath sample is a constructive refusal. So when my client failed to blow a sample that was read by the machine, it was a constructive refusal. It comes with all the costs and benefits of a refusal. The costs are you lose your license.
For how long do you lose it?
I
120 days.
I think that was 120 days. I think that's
she
correct.
only did 45, but I'm not sure if that's, I didn't know where that came from. Is that
Oh,
right?
well, that was, yeah, after the conviction. But so that there are costs to it, just like an actual refusal. But we would argue there are benefits too, and the benefit is that the law that Justice Cordy was just pointing out, which holds that this is inadmissible. So I would argue that when she failed to blow a readable breath sample, it was just the same as if she had sat down at the machine and said, I changed my mind. And it's clear that that can be done.
If you can help me, the appeals court has disagreed with you on that? Is that, can you
I
talk
believe
about
they
that?
did. In the Curley case, the appeals court said, and I think this is the government's argument, that because there was initial consent, because she said, I'm going to take this test, that opened the door for whatever happened afterwards. The Curley case, when you read it, it doesn't really, I don't think it comes to terms with this issue that it's a constructive refusal. If it says right on page 8 of the record appendix, it has the report, it says refusal, and it's required to be a refusal by the code. So whether that's, whatever one thinks of the law, that's sort of the way the law is, I would argue. And the Curley case also, the appeals court had a much better case, I think, for the government there, because the person had, first he had failed to blow into the machine, and then he feigned dehydration. He was taken to the hospital. He was overheard saying, I pulled a fast one on the police. So there was a lot of other corroborating evidence. And certainly there are cases where failure to blow a readable sample, there could be incriminating evidence that the government could put into the case without actually discussing the breathalyzer or the refusal. So in that case, the thing about I pulled a fast one, that could have certainly been elicited without going into the breathalyzer issue.
Okay.
So I'm sorry, I'm trying to sort out what your argument precisely is. So here, there was a language issue. She attempted to do it. The person showed her, person did it himself, the officer.
Yes.
And then she was unable or chose not to do it, depending on your point of view. Why is that not a jury issue as to whether or not her inability to do it was caused because she didn't understand, as opposed to she was trying to avoid the consequences of doing it correctly?
Well, that would be the argument. My argument is simply that because it's deemed it's a constructive refusal as a matter of law, so it shouldn't have gone to the jury at all.
Because, is that because of the Article 12, or because of the statute, or because of the reg, or?
It's because of the interplay of the reg and the statute.
Okay.
The reg makes the reg requires that it be deemed a refusal after so many tries. And it was deemed a refusal here, as a matter of fact.
And the reg doesn't address this issue about giving consent before.
No,
Of course, but of course you would have given consent if you're going to,
exactly.
yeah, I
Yes,
mean, it's
yes,
implicit
yes.
in it, right?
So
yeah.
my argument, it's sort of separate from the fact that she's a Spanish speaker, would apply to anyone. It's simply failure to provide a breath sample is a constructive refusal, and it's the same as an actual refusal. It comes with all the costs and benefits.
But one concern I have is that, okay, so it's a refusal. There are consequences to refusal, and if that were to happen and she were to lose her license, could she not come forward and say, wait, this is terribly unfair, that I'm now losing my license because I was not able to understand the translation well enough to know what I'm supposed to do. So you are penalizing me for my inability to speak English by taking away my license.
Well, that's sort of a separate issue, I would think. It's clearly the whole interplay of the laws presupposes these machines work well, and that they can't have a person sitting there pretending to blow for hours at the police station. So at some point they have to cut them off. Now, as an empirical matter, is that true? My understanding is actually there's litigation going on now in the district courts about these very, I think it's called Alka-Test 9510 machines. So
We know that.
yes, so she may have a claim on that ground, but that seems to me that's a separate issue.
You turn to the confrontation issue. I guess one concern I have is that these police departments are all using, quite properly, this interpreter phone.
Yes.
So that they can find a Creole interpreter somewhere, but that Creole interpreter could be in India, they could be in Haiti, they could be anywhere. So if you say they have to bring that person to testify, the cost and logistics of that become quite formidable.
Well, that's true, Your Honor, and I think when you read together the Crawford case and the Melendez-Diaz case and the Bullcoming case, that's really not an argument that's open at this point.
Well, is that really the case? I mean, the whole idea of an interpreter is not that they're providing hearsay, is that they're simply a conduit. They're the machine. What if it was a Google machine that was doing this?
I would submit, and I was hoping we'd have an amicus from translators or linguistics professors or people who know more of this than I, but
Well, the
I
Maryland
submit that's
Supreme
obviously
Court has
not-
helped you a lot.
That's obviously not true. I mean, it's not like dots and dashes and Morse code. Obviously, when you interpret, just the word interpreter, there's discretion, there's judgment. That's all grounds for cross-examination.
But isn't the interpreter, in a sense, once your client has agreed to use the interpreter, the agent of
No, that could be the case, but I disagree here. It's a police station interrogation.
Yeah.
They produce the interpreter. I don't think the law has changed on this since the Storty case, which I cited.
I'm just saying that Crawford doesn't seem to necessarily apply, where the interpreter has never been viewed as some sort of separate witness.
Crawford applies when there is a declarant. So the issue here is
Who's the declarant?
who is the declarant?
Right.
Well, our position is my client is the Spanish-speaking declarant, and the translator is the English-speaking declarant. And if there's some problem with the translation, and maybe there wasn't here, this was probably not a super elaborate translation, but whatever law the court lays down is going to apply to
But if
the
you're not,
4-hour.
I take it you did not, at the trial level, trial court level, it was never an issue that the interpreter did not interpret adequately. That was never an issue.
Well, what happened was the trial counsel objected. The judge said this is risk for cross-examination. And basically all he could do, because it was all that was open to him, was to ask the police officer, you don't know anything about this person's qualifications or dialect. You don't know anything about the
I'm not talking about the confrontation question. I'm talking about the competency question, a question of competency.
Yes, I mean, that's all he could do. He tried to make a jury question of it.
The competency of the interpreter to interpret the Spanish to
Right.
English.
We don't know anything about our competency.
So it wasn't an issue below.
The officer testified, I don't quite know, I mean, it
The
could have been
officer
objected to, but he said she's certified and registered.
Exactly. I don't know what the foundation for that was. And there wasn't really much that the trial counsel could do other than try and cross-examine him with those questions I just mentioned. So that was the extent of testing her.
Oh, okay, but so where the competency of the interpreter is not a live issue below, why does it even raise a confrontation question? Why isn't the conversation essentially between the trooper and the defendant?
It's because even if you have, I mean, so if you go into the bookstore, there'll be various copies of War and Peace, and they're all different translations. The gist of the books are all the same, but they're not going to read the same because different people have made different judgments.
Yeah.
It involves judgment, involves discretion, and therefore it's grounds for cross-examination, we'd argue. In the Bullcoming case,
was it grounds for, there wasn't any cross-examination?
No, it's a substantial risk question, but it's, right? I mean, it could be a substantial risk
right?
question.
That's the
That's
gist
your
of
argument.
it. And here, I mean, this was a short examination, and it's in Spanish, presumably. There are Spanish speakers available. But whatever law the court lays down will apply to 4-hour murder interrogations in
Can I
Chinese.
ask you this question? Let's say, I'm thinking about the Portillo case, which was about putting in translated of a Spanish-speaking tape in interrogation. But let's say that, and I don't know in this case if this is true, but let's say that it was the case that, as in the Maryland case, this was videotaped and audiotaped. The whole interrogation with the person on the phone and what the question put to the Spanish-speaking defendant, the conversation, if there is any, between the interpreter and the defendant, and then the interpreter's answer back.
Yes.
All that is recorded. Would that solve your problem?
I think that might have solved the problem. If I don't recall that, and I'll defer to my sister on this. I don't recall that there was.
No, I'm
anything
just
in the
wondering
record
going
about-
forward, if
about it
that were
being-
the case.
Yes, I think it would solve the problem if the defendant were allowed to retain, if there were some good faith belief that there's a mistranslation or something.
Was this on a recorded telephone line?
That's what I said. I would defer to my sister. I don't recall if the record even speaks to that one way or the other. I think the record is just silent on that. Getting back to actually Justice Cordy's issue on the agency issue, that's the argument that the government has made. But we cite the agency law in our brief, and the law, one is an agent if they act on behalf of and under the control of the principal. I don't think there's any realistic way to look at what happened here and say, yes, my client, who had just been arrested and was presumably waiting to try and get out of the police station, was the principal here, and this translator, who she knew nothing of, had never spoken to before, had no relationship with, was her agent.
Certainly not her agent for all purposes. The question is whether that person was the vehicle for her to make her statements.
Well, they were certainly that, but that doesn't make them her agent. They were not acting under her control. Now, one might say, well, they were acting kind of for her benefit because she wanted to get released from the police station, but that...
So if we go back to agency, let's go back to Commonwealth versus Vose, V-O-S-E, an 1892 Massachusetts case, but it's about agency and interpreters. Yes. Just because the interpreter has been selected or compensated by the police department doesn't mean the interpreter can't be an agent of your client for these purposes.
The Vose case says that it's when you have two people using the same interpreter, you can ignore the interpreter for purposes, I think, of hearsay. That case is dealing with, not confrontation. But in any event, it says they have to stand in the same relationship to the interpreter, for the interpreter to be a joint agent, for them to be joint principals. That's just, I would submit, it just, you would have to ignore what really happened here to think, oh yes, my client was in the same position as the Stoughton Police Department, who have a long-term relationship with.
Well, is there any evidence that the interpreter had a motive to misrepresent? Certified, registered interpreter had a motive to misrepresent what your client
No,
was saying?
there's no evidence.
But
But of course, how would
point-
we know? I mean, she wasn't there.
Isn't your point, though, that that's all nice about agency, but that's sort of at a time when It's pre-Crawford.
Yes, Justice.
Where the issue is reliability of the hearsay.
Yes, Justice Botsford,
And
that's
that,
exactly
and
right.
that Crawford changes the game
That's
completely.
right. Even if the government were right on hearsay, which I dispute for the reasons I just gave, that's what happened in Crawford. Mrs. Crawford she had incriminated herself and her husband, and there was no hearsay issue because it was a statement against penal interest. And the Supreme Court said, well, that may be, so you're fine there with the evidence law, but you're not okay.
Oh, but the question is, who is the declarant? Isn't that the question? Who's the declarant here? If the
That is the
declarant
question.
is your client,
I
then
agree.
there's no problem.
I agree. But for all the reasons I've just said, I don't know. You would have to ignore there was a translator. You would have to agree the translation from English to Spanish is like Morse code, dots and dashes, and there's only one right way to do it, and you can just ignore it. And I would submit that's not.
What were the, going to Justice Spina's question of what's the substantial risk here, what were the statements she made which mattered in the case?
Well, the statements where she, this kind of ties in with the breathalyzer part. It was that everything she said, she understood what he was saying. She spoke about her friend drinking, which I don't think they actually elicited testimony that she had been drinking or that there were
No, she said her
bottles
friend
in the
was
car,
too,
but
didn't she say her friend was too
drunk to drive
intoxicated?
home, so she borrowed her friend's car.
But she didn't say she was drinking.
That's true, but it was not an incredibly strong case for the government, and just that evidence right there, I would suggest, together with the suggestion of consciousness of guilt about blowing into the breathalyzer, given it was a close case, it could have tipped
Well,
the
you say it's
scales.
a close case, but wasn't there there was a civilian witness that had followed her on driving for about 10 minutes and testified she was all over the road?
That's true, it's true. But it was in the middle of the night, and her argument was, I'm a 21-year-old driver coming home from someone, I live in Brockton, I'm in Stoughton, I don't know where I'm going. But the jury didn't buy it. I mean, they were briefly deadlocked, but it was, so I guess that's the substantial risk argument there.
Okay, thank you.
Thank you, Your Honors.
Good morning, Your Honors. Varsha Kokafka for the Commonwealth. I'd like to acknowledge the amicus brief that was submitted by the Massachusetts Chiefs of Police Association. So in the middle of the night...
Was it a recorded call?
I do not believe they're recorded. I can't say definitively, but the record is silent as to whether it was.
Ms. Kakak, you don't think, I mean, you didn't address the Charles case at all. You don't think that's an issue you have to even think about?
Well, the 11th Circuit is kind of an outlier.
Well, the
and
Maryland Supreme Court has just followed them.
The Maryland Court of Appeals has adopted that. If you look at those cases, both instances, the content of what was said by the defendant was very critical. First of all, taking the Taylor that just came out last week, that was a 5-hour interview by a defendant that used sign language. There were interpreters there. It was videotaped.
But the point, I mean, the legal point isn't, that's a factual distinction. But the legal point seems to me, I think, that what those cases say is the agency argument, in part, has been superseded by Crawford. And do you disagree with that?
I do disagree. Crawford doesn't apply here. You don't consider the defendant's statements, they are not hearsay, whether you say that they came out of the defendant's mouth or through an agent or through a language conduit. It's the defendant speaking, and no interpretation is necessarily exactly word for word.
Can't you say that about a gas chromatography test?
No, the Bull Cumming and Melendez-Diaz don't apply to this at all.
Well, if this was a third party, if this was a friend of the defendant or a witness who was having a conversation with the defendant the next day, and the police found out about it, and they got a statement from this third person making statements of the defendant, the police officer couldn't testify as to what this third person said. They'd have to bring the third person in. Why isn't the interpreter in the same situation as the third person?
It's not at all, and I did think of that example, Your Honor, but this officer is right there. He's set up the language line, which is a neutral party that's used for the communication and the convenience of both sides. The police have an interest and an obligation to communicate with the person that was arrested for OUI at 3 in the morning. And that person has rights to be understood and to realize what's going on. That is why she was brought to the station without field sobriety test. But the difference is that this officer is sitting there, and it's on speakerphone, and the interpreter, it's going back and forth, and he's also observing the defendant, nodding with each statement that is told to her. He's demonstrating physically. So your example of someone that's a friend of the defendant outside of this whole thing, that the officer is not present and the interpretation or whatever was said, that would be pure hearsay. I agree.
First, because we don't know what the defendant was nodding in response to. It could have been a statement from the
could have
interpreter
been-
saying that this police officer is a...
What if the interpreter on the phone is just completely bonkers? I mean, it's a complete misinterpretation. How is the defendant ever going to be able to get to that?
Well, that's the reason in certain circumstances there's room to discuss a problem, but not to issue a blanket rule that this is hearsay and that it violates the confrontation clause.
Well, I take it in this case, the defendant was provided discovery that contained this conversation in English, which was presumably translated in Spanish so that he could see in black and white what a police officer says the conversation was.
In this case?
In this case.
In this case, the only conversation was the Miranda warnings and the OUI warnings. What came out of trial is that the officer asked where she was coming from. And she used this to her own advantage because she
But
said...
were these statements all provided in discovery to the defendant?
I think that, yes, the police report is a very short paragraph.
And it has all this information in it?
It
So,
says that
so
she was...
I'm sort of thinking out loud. So the defendant could then say, "Hey, this isn't the conversation that I had with the interpreter," and could have, but hasn't said that. He hasn't made that an issue.
No, I would say it was very truncated. You know, she was given her warnings in English and Spanish. That's what the report
What's the it in that
says.
sense? You mean the conversation? I mean, the question is, what did the... Okay, whatever happened in the police station happened. She's charged. What discovery package is given to the defendant at that point that relates to what happened at the police department?
Well, there was no recording, so that wasn't given. There was police report. I don't...
And the police
no
report is
transcript.
just a little thing, right?
And the refusal, the repercussions of the results of the breath
Does it
test, which-
represent does it represent the conversation that was going on between the police officer, the defendant, through the interpreter?
The conversation was the warnings, and that's it, and that the defendant understood,
And not the instructions
The
for the
instructions
breathalyzer?
about the breathalyzer.
no, the police
So
report,
the first time the defendant heard about that was at trial?
I suppose so.
No, the interpreter was part of the instructions about the breathalyzer, I think.
Yes, but if I understand the question, how could she challenge what was said to her before trial?
Yeah.
Well, I will point out that before trial started on the day, the judge was very aware of this interpreter issue and kept asking, was the language line still on for the instructions on the breath test? The answer was yes. Was the language line still open when she was taking it? So the judge was very cognizant of the importance that there was an interpreter throughout the taking of the breath test.
Can I ask you a little, this language line, tell me more about it. Does every police station in the Commonwealth subscribe to this now?
I have tried to find out and even look up the name of the interpreter that was in the police report, and I couldn't find anything really on this language line. I know there are language lines in district courts. I've been told that sometimes they've been used with,
Presumably, those have been arranged by the court system in some fashion.
They have,
yes.
they have.
So, this, I think that it's a system that police departments use because they don't have, there's one case,
You said this is a certified interpreter. How do we know all of that? How do we know what the...
registered certified is what the officer testified.
But
But how
that's
does
all
he
we
know?
know.
How does he
And
know?
there's a protocol that it has to be on speakerphone, everyone has to hear, that he gives a PIN number. It's not, it's a very established procedure.
It's an established procedure, but we have no idea who the service is, where it comes from.
I was not able to find out more.
Do we know if they record the conversations?
I do not know.
Is there any reason why we could not solve this problem by making it a recorded line? So that
A
everybody can see
recorded
what was
line.
said in English and in Creole or in Spanish?
A recorded line, well, it's kind of the D. Giambattista issue where the court has not said it must be recorded, but there's an
Not yet, but I mean, the
instruction.
question is there any reason why we should not go even beyond Giambattista and say, if you want to offer it, you have to record it so that the defendant can see what was said in his or her language and what the translation was?
I don't know what, if that's feasible or if
Well,
it
it's
would
certainly
work.
feasible because, I mean, it's, if you think about, I think it's feasible because what you're doing is recording, you're recording and
Conference call.
what's going, yeah, and it's what's going on in the police station also. So, I mean, you can definitely have a recorded conversation because we do telephone hearings all the time, but you can also record what's being heard in the room in the police station, which would include the question in English, the translation by the person on the phone to the defendant, and the defendant's answer in that language, and then what the person on the phone is saying back. All of that could be recorded without too much difficulty, I think.
I can't speak for the level of difficulty, but I think it's
I
definitely
mean, isn't this,
possible.
isn't a case involving OUI exactly the kind of case you would need an accurate translation? I mean, how many words are there for being drunk, inebriated, buzzed, a little, I mean, you say that in English and there are variations for which a translation could matter a great deal. Did the person say in Creole, I am drunk, or did the person say, I am buzzed? Did the person say, I had a few, I felt a little bit woozy? I mean, the variations on the theme can be quite considerable, especially in an OUI case, and the words might matter.
If the person wanted to talk to the officer, not just taking the test, which is a physical test, if there were statements along the way, I suppose. But this was strictly the information about taking the
Okay,
test.
I'm aware of that, but I mean, there are other OUI cases in which the person is describing how many beers or drinks they had, how they felt. The
well-
translation of that could be incredibly important.
I mean, you had Miranda warnings here.
Yes.
And so presumably, if she heard them and said, yes, it's fine, and then there were questions put to her that she answered, substantive questions that, like Chief Justice Gantz is just talking about, I assume the Commonwealth's going to want to put that in evidence.
Yes, and also it would probably show up in a police report, but a recording would be definitely more memorializing it than leaving it to what the interpreter comes back with.
Just another question on the interpreter. There's a reference to it being a Spanish-speaking interpreter, and there's so many different kinds of Spanish as there are most languages. There's no effort, as far as I could tell, to identify whether this was this particular, whether it was South American, whether it was Spanish, Hispanic, whether it was Mexican, whether it was Puerto Rican. And from the translations and issues about interpreters that have already come up to the various courts I've sat on, there are differences that are quite profound in choice of words when you're trying to even describe something as simple as blow into this tube with your lips tightly around the nozzle. Is there anything like that reflected?
No, there's nothing reflected that was asked on cross-examination, but one example is that The defendant made her statement about why she drove and that she thought it was the right thing to do. And this came out, there was no objection. It was essentially and effectively interpreted correctly. There was no challenge to that by defense counsel, that that's what she said, and that's what the interpreter told the officer. That's content, that's more nuanced than the actual Miranda warnings, which I think you can believe that.
You'd be
and
surprised, actually, how they come across sometimes in translation.
But the difference here is it is a language line. You would, a certified registered interpreter who is doing this on a language line. It's not a bystander that speaks Spanish.
No, I
It's not
understand. So my
another
question
police-
was, what kind of Spanish? Was there any is there, do you know?
I don't know, and it
Does
was...
you say Spanish, and whoever speaks some kind of Spanish, it comes on?
Oh, as far as the distinctions,
Correct.
there may be an ability to target it
So the record
more.
doesn't reflect that in this case there was anything other than someone,
Yes, I
certifies
don't
as
know.
speaking
There may
Spanish.
be, particularly if there's a difficulty with communicating.
well, you wouldn't know.
Well, the defendant,
The defendant would think she's being communicated to, but she wouldn't know if it were inaccurate, would she?
well,
She doesn't speak.
She would obviously have problems understanding, I would think, if
She
it
would
wasn't-
hear what the Spanish-speaking interpreter says to her was what the officers said to him, but she wouldn't know if it were incorrect.
That is true, but she
So that's
would-
kind of the point.
could certainly demonstrate, I think in one example, the defendant kept saying, you know, one of the cases that the defendant cites here, he didn't understand what was being said, whether it was a deaf person or a Spanish-speaking, but he showed through his gestures that he didn't understand what was being said to him and what he was supposed to do.
That's probably a good case.
So here, there is nothing like that.
All right, thank you.
Thank you.
Ask the court to affirm this conviction.